Welcome to the deep dive. When most people hear maintenance, they probably think about a monthly payment, right? A basic obligation.
Yeah, just a civil thing.
Exactly. But what we often miss is the incredibly complex legal system behind it. It's this whole structure designed to enforce that duty. And it's not just civil law. There are real criminal consequences involved, too.
That's spot on. The source material you send over, the Maintenance Act 99 of 1998, it's fascinating because it's constantly being updated. The latest consolidation was October 11th, 2024.
So it's very much a living piece of legislation.
Absolutely. It's not just sitting there. It's designed, as the preamble itself says, to create a fair and equitable maintenance system.
And that's really our mission for this deep dive, isn't it? To unpack how this system actually works. We want to look at everything from, the big constitutional ideas driving it, right down to the practical tools used for enforcement.
Right. To show you, the listener, that this isn't just some minor financial arrangement. The state views it as a really fundamental duty. Okay, let's get into it.
So where do we start? The foundation seems key. What's the core philosophy here?
Well, you have to start with the Constitution. The Act is explicitly grounded in the 1996 Constitution of South Africa. Its whole purpose, stated right up front, is about building a society based on social and economic justice, equality, and fundamental human rights.
So maintenance law isn't just about money changing hands. It's actually a tool to achieve those bigger constitutional goals.
Precisely. It's about realizing fundamental rights, especially for children. And it doesn't start at the national level. The preamble makes a point of linking the Act to international commitments.
Like which ones?
It mentions the World Declaration on the Survival, Protection, and Development of Children, and very importantly, the UN Convention on the Rights of the Child from 1989.
Okay, the Convention on the Rights of the Child. Remember, Article 27 is crucial there.
That's the one. Article 27 basically says every child has a right to a decent standard of living, and it requires countries' states to take all the necessary steps to make sure maintenance gets recovered.
So the Act itself acknowledges that the old system maybe wasn't cutting it internationally.
Yes, the preamble notes the Act was passed partly because the previous setup possibly falls short of those international obligations. It was, in a way, an attempt to catch up and deliver on those promises.
That sets a really high bar, philosophically speaking.
Yeah.
But, okay, philosophy needs structure, right?
Mm-hmm.
How did the Act actually build the machinery, the courts, the people, to make this happen on the ground?
Good question. That's laid out in Chapter 2. On the institutional side, it's pretty straightforward. Every local magistrate's court also functions as a maintenance court. Simple enough.
Okay.
But the real operational core comes down to the specialized roles created.
Right. You mentioned two key figures, the maintenance officer and the maintenance investigator. What's the difference there?
So the maintenance officer, often it's a public prosecutor who's given these specific powers. They're the ones who handle the legal side. They take the complaints, they start the official inquiries in court, manage the case flow. The Act even stresses creating a dedicated and experienced pool for this.
Okay, so they run the legal process. And the investigator. They sound more like detectives.
Pretty much. The maintenance investigators are the ones doing the legwork. Their job is literally to find people who might be dodging the system, serve the official papers like subpoenas, and gather evidence, maybe taking sworn statements. They make sure the court's orders can actually reach the right person.
Got it. So that structure leads us to the core legal requirement itself, which is in Section 15, the duty of parents to support their children. What does the law actually demand?
It's basically codifying and enforcing the common law duty. And the scope is broad. It covers, everything a child reasonably needs. The Act specifically lists food, clothing, housing, medical care, and education.
And it's a joint duty, which sounds simple, but how does the court figure out who pays what?
That's key. It's jointly owed by both parents, and their shares are worked out according to their respective means. So the court has to look at both parents' financial situations, not just the one expected to pay.
So it's a proportional thing based on what each can actually afford.
Exactly. It stops arguments like, well, I don't have the kids most of the time, so it's all on the other parent. The court looks at capacity.
And Section 15.4 makes a really big statement about children from different relationships, doesn't it? This seems like a major shift.
Oh, it's huge. First, it says the duty exists whether a child is born inside or outside of marriage, complete equality there. But Section 15.4 goes further and explicitly abolishes any old law that gave priority to paying maintenance for kids from a first marriage over kids from other relationships.
Wow. So all children have an equal claim, legally speaking, regardless of the parent's marital history.
Correct. It puts all children on the same footing for maintenance rights. It's a fundamental leveling of the playing field.
That really is a societal reset button in legal terms.
Yeah.
Okay, let's pivot to where things often go wrong.
Mm.
Enforcement. What happens when someone just disappears? How does this system find people who are actively trying to avoid payment?
Right. This is where the Act gets quite assertive, especially with the newer amendments. The process starts with a complaint to the maintenance officer, as we said. But if the usual ways of finding someone fail...
Like sending letters, trying known addresses.
Exactly. If those reasonable efforts don't work, Section 7.3 kicks in with some pretty powerful tools.
You mentioned digital tracing earlier. How exactly does that work?
If they can't find the person, the maintenance court can actually issue a formal direction to electronic communication service providers, think your mobile phone company, maybe even internet providers.
Seriously. They can order phone companies to hand over details.
Yes. If the person is a customer, the court can order the company to provide contact information. It basically acknowledges that hiding physically is one thing, but hiding your digital footprint is much harder these days.
That's like a state-backed digital search warrant for finding maintenance defaulters. And what if the person making the complaint can't afford these searches or, say, paternity tests?
That's another important point. The Act anticipates this. Under Section 7.3J, the court can order the state to pay the costs for tracing if the complainant doesn't have the means.
Okay.
And similarly, if paternity is disputed, Section 21 allows the maintenance officer to ask for an inquiry into whether the state should provisionally cover the costs of scientific tests, like DNA tests, if the mother and alleged father can't afford them.
So lack of money shouldn't be a barrier to getting maintenance established or enforced. That seems to be a consistent theme.
Definitely. It's about access to justice for the child, regardless of the parent's financial situation.
And once an inquiry is actually happening in court, Section 10 pushes for speed, right?
Absolutely. The language is quite strong. Courts shall conclude maintenance inquiries as speedily as possible and must limit postponements. There's a clear recognition that delays directly harm the child's well-being.
Okay, makes sense. Now for the really sharp end, the orders and how they're enforced. Once a maintenance order exists, what teeth does the system have, both civil and criminal?
Right. Chapter 5 covers the main civil enforcement tool, which is very effective, the attachment of emoluments order.
That sounds like wage garnishment.
Essentially, yes, but broader. Section 16.2 allows the court to order anyone who owes the debtor money on a regular basis, an employer, obviously, but even the administrator of a pension fund to pay that money directly to the person owed maintenance or a designated state account.
So they bypass the defaulter entirely and grab the money at the source. And emoluments, that term covers more than just salary, doesn't it?
It's incredibly broad. The definition includes any salary, wages, allowances, or any other form of remuneration, whether expressed in money or not. And here's the kicker. Section 26.4 specifically says that even things usually protected, like pensions, annuities, gratuities, or compassionate allowances, can be attached.
Wow, attaching someone's pension. That shows just how seriously the state views this obligation. It's hitting their future security.
It really does. It elevates maintenance debt way above typical commercial debt. And these attachment orders get priority. Section 16.3 says payments under this notice generally have to be made before payments for almost any other kind of court order against that same money.
Okay, so the civil tools are strong, but what if someone deliberately avoids having traceable income? What if they just refuse to pay, even if they could?
That's when we move into Chapter 6 and the criminal side. Under Section 31.1, simply failing to make a payment required by a maintenance order is a criminal offense.
An actual crime. What's the penalty?
It's serious. Upon conviction, they face a fine or imprisonment for up to 3 years.
3 years in jail for not paying maintenance. That sends a message. And what about the excuse, I can't pay, I lost my job?
The law anticipates that. Section 312 is crucial here. A defense of lack of means won't get you off the hook if the reason you lack means is your unwillingness to work or misconduct.
So deliberately quitting your job or, say, getting fired for bad behavior doesn't work as an excuse.
Exactly. It closes that potential loophole. You can't engineer your own poverty to avoid paying maintenance.
And then there's the credit rating impact. That feels like a very modern consequence.
It is, and it's twofold. First, when a court grants a civil warrant of execution or an attachment order under Section 26.2a, it has the option to report the defaulter's details to credit bureaus.
Okay, so that's discretionary.
Right. But second, and this is the bigger one, if someone is criminally convicted under Section 31 for failure to pay, then Section 31(4) says the maintenance officer must report their personal details to the credit bureaus.
Mandatory reporting on criminal conviction. That can mess up someone's ability to get loans, rent a place, maybe even get a phone contract for years.
Absolutely. It's a long-term financial consequence layered on top of potential fines or jail time.
And the system allows these criminal and civil tracks to overlap, doesn't it?
Yes, very flexibly. Section 40 allows a court that convicts someone criminally for non-payment to also, at the same time, grant a civil judgment for all the back pay owed. And Section 41 even allows criminal proceedings to be converted into a maintenance inquiry if it makes more sense. It's all geared towards getting the maintenance paid one way or another.
Okay, so stepping back, what does this intricate system really mean for you, our listener? It seems the Maintenance Act is this powerful mix, right? On one hand, it's driven by these really high ideals of social justice from the Constitution.
Yeah, the constitutional rights, equality.
But on the other hand, it uses some incredibly tough practical tools, electronic tracing, attaching pensions, criminal charges, hitting credit scores to make sure those ideals become reality.
That's the key takeaway, I think. The sheer priority the state gives this duty. When you see mechanisms like attaching pensions or the unwillingness to work clause or mandatory credit reporting after conviction, it shows this isn't viewed as just another debt.
It's treated as fundamental.
Exactly. It's directly tied to the basic human rights of children, and the state is willing to use some pretty extraordinary powers to enforce it.
Absolutely. And just think about that. Remember how the preamble called this act an interim measure back in 1998, waiting for more law commission proposals?
Right, that's interesting context.
Given how much has already been added since then, the electronic tracing, the specific criminal elements we discussed, how effectively have these changes actually fulfilled that goal of improving lives and ensuring equality? And looking forward, what else might even be needed to fully realize that huge constitutional promise? That's definitely something to think about.